um, for the Ohio Real Estate Investors Association, although I see many people that I know who are not from Ohio, and that's not just fine, that's awesome. We love it when you come to our sit downs and to our national summit and to our day at the Capitol and all the stuff that you do. So, welcome to everybody. If you don't know me, my name is Vina Jones Cox. I'm the vice president of the Ohio Real Estate Investors Association. The president, Scott Ellsworth, is also with us today, as is the what's your official title, Deborah? She is the person who keeps everybody else's head on straight. That should be your title.
I guess association manager is what you all labeled me.
Association manager, Deborah Collins. And we are uh, doing this series this year of third Sunday night calls because we just have our two big events a year. We have our day at the Capitol, which is in May this year, and you'll be hearing a little more about that. And then we also have our national summit in November, and stuff comes up that's not in May and not in November. And we decided we should probably get together a little more often and talk about stuff that comes up that is important to you, either strategically or legislatively or legally or whatever. And tonight, as you know, we have Maurice Thompson, who is the executive director of the 1851 Center for Constitutional Law, uh, which is a public interest law firm that basically sues governments for stuff. And there's some really interesting things going on right now that they're primarily going to affect Ohio, but once a case like this has been won, it's a whole lot easier to kind of grab what the case was and what the arguments were and transplant it someplace else. So, Maurice, welcome. Um, I guess let's just start with kind of your general, like, what is your place in the world of property rights? I mean, we're already out there like lobbying and talking to politicians and trying to get them to do the right thing, but you kind of come into play after that happens.
I'd mostly agree with that, although I think that litigation can be an important deterrent. And if we win our cases, then we come into play before, ideally, where you can go to that government meeting with our prior litigation victory and be able to show the city council or whomever it is that what they're doing may be unconstitutional. So, on some ends, we're on the front end and the very front end and the very back end. And what I mean by the back end is that the local government, usually state government, has already passed the regulation, the mandate, the taking, the inspection, whatever it might be, and actually attempted to enforce it against you, ideally, or just before you fear they might enforce it against you. That's sort of where we come into play and represent your right to do anything that's peaceful, that doesn't inflict harm on others. So the Reagan quote was, if you can't make them see the light, make them feel the heat. So when making them see the light has failed, and it usually does, for better or worse, we can help you make them feel the heat in certain select scenarios.
Okay. So can you also explain what public interest law firm means?
Yeah, we don't charge legal fees. So we take strategic cases to make property rights broader. And that's our bailiwick. So everybody's kind of heard of the ACLU by now, which are people who are interested in certain kinds of civil liberties. Well, there's a whole range of public interest law firms now that people would say generically are sort of on the right. I don't know if that continuum is any use anymore, but we protect economic liberties, entrepreneurs' rights to do business, taxpayers' rights, homeowners' rights, parental rights, healthcare freedoms. So do all of that in case this precedent it's that no cost to our clients. So we've never charged a dime.
Okay, that's him, not me, right? He was dropping out. Okay.
Yeah.
Oh,
Yeah.
okay.
Okay, so yeah, you seem better now, but unfortunately we may have to have you turn your video off to make sure that the
Yeah.
audio works. Okay, so you're working on a big old double handful of really interesting cases right now that if they work, if you win them, will have some pretty significant effects on people who own rentals, people who own student housing or shared housing or pad splits, and everyone who is terrified of fair housing testers. So, can you talk a little bit about those three cases that are going on right now?
Yeah, sure. And by the way, if I'm talking and I'm breaking up and you want me to turn the audio or the video off, just pop in and interrupt me anytime and I'll just do that and continue to answer your question. So, all right, I got a message that sounds fine. Good, thank you. Um, Fair housing, you asked about occupancy limits, and the other issue you asked about what?
Uh, the fake warrant search inspections.
Yeah, that's right. Let me start with that one because it's the one we've been on the longest. We've been on this issue for about a dozen years and probably have developed the most expertise of anybody in the country in warrantless inspections of property, homes, businesses, whether it's papers or physical properties of the home itself in the civil contexts. So people all too often think of home inspections and Fourth Amendment type issues as criminal matters only, but the Fourth Amendment and the state analogs to the Fourth Amendment apply equally in civil contexts where the government wants to come in and just look around for a building inspection on the front end, on the back end, a rental inspection, what's called a pre-sale or a point of sale inspection. And we've had tremendous success over the past dozen years in establishing the principle that a search warrant is required before government can do that. Now, that raises the question on what kind of a warrant is required. What does the government have to prove? And we've already said we're going to win these warrant cases first, and then when they attempt to create a candy-coated rubber stamp warrant that just says we get the warrant because we get the warrant, we have no evidence, we're going to stand up and fight for that principle. And we have a very helpful client who has helped make that possible out of North Canton, and we've taken that case up to the Ohio Supreme Court, and we're just waiting for a decision. Our position there is that you need probable cause to get the warrant, which is what the Fourth Amendment says and also what state constitutions say. Some state constitutions say more than that. So some states will be better on this than others. But that means you need real evidence of an actual code violation to get into the house. And when you have that evidence, it can't just be, hey, there's peeling paint on the garage, so we get to break into the house and search the entire home from top to bottom. There has to be a nexus between what the evidence of the problem is and what you want to search, just like in the criminal context. So we posited that to the Ohio Supreme Court. There are very few state Supreme Court cases on this. The federal Supreme Court during the Warren Court era, the late 60s, basically said that sort of, they call it an administrative warrant. This sort of candy-coated warrant works fine at the federal level. And people are starting to wake up and realize that if you read that decision, it makes no sense whatsoever. It's not grounded in history or the text of the Constitution itself. It's just a bunch of public policy arguments about majority rule, which makes no sense. So we're increasingly across the nation bringing these cases in state Supreme Courts to try to establish the principle. So, and obviously the reason we're trying to do that is you don't want the government in your house unless absolutely necessary. So you want to keep them out whenever you can. And the reason for that is because they come into the house, they walk around, and they look for things to justify their job and to justify coming back and charging you inspection fees. And on the one end, many of these mandates are all about inspection fees. Local governments want to find a way to backdoor tax you without taxing you through the front door through passing a levy through increased property taxes. So some local governments don't even care about the inspection. If you pay the inspection fee in many places, they never show up like they're supposed to. And it's just a bribe. It's a go-away fee. It's a racket, and you're actually kind of lucky, though, if that happens to you, because the flip side is they take that responsibility very seriously, and they show up and they pick apart your home, especially if it's an older home, every square inch of it, and how your tenants live if they're living there, if it's a rental inspection, every square inch of it. And at that point, they're looking at your pipes and they're looking at your wiring, and they're telling you you have to replace things that don't actually need to be replaced, that are perfectly safe. And you're up with thousands and thousands of dollars in mandates. Or if it's a point of sale or a pre-sale inspection requirement, you're left in a situation where it kills the deal and you can't sell the home or buy the home without fixing all those things first. So it's just a mess. So that's the inspection front. We're waiting for a decision. We're hopeful we're going to get a ruling from the Ohio Supreme Court that the kind of warrant you need has to be supported by actual evidence. Now, if you want me to go on, how's my audio still good?
Yeah.
Great. You asked about occupancy limits. Occupancy limits, another issue that we've been on for a long time. I guess we are now a decade into occupancy limits, and we are a decade in. For those of you who I don't know, I will tell a story, the brief version, it'll be redundant to some. I've been a landlord for 25 years, and I was a college landlord in Bowling Green, Ohio. I mean, many of my tenants were college students, graduate students, and I got a notice in 2017, I believe it was, that I was required to evict a fourth college student from one of my rental properties, a 4-bedroom home, because the maximum was 3 unrelated individuals in Bowling Green at the time. And I was thrilled to get this because I had wanted to challenge this for a while. So I filed a preliminary injunction in federal court in the Northern District of Ohio in Toledo. And ostensibly, by 2019, we won a summary judgment order finding that the Ohio Constitution was more protective of property rights than the federal baseline. Here again, a case where what was called the Warren Court in the 60s and 70s had diminished property rights across the nation through the federal Constitution, in a case called Bell Terre that you'll see come up if you care about this issue. And what that court held is it was arbitrary to limit large homes to 3 or less individuals. And there's this city where there are many 4, 5, 6, 7, 8-bedroom homes that were limited to 3 individuals. And like many cases, we have the Baptist and the bootlegger theory of regulation. That is to say that the apartment owners on the outskirts of town wanted to vigorously enforce this regulation against the landlords who owned large homes in town, to break up those homes and create more tenants to spread across the entire town and move them more on the other side of the highway, further away from the city center, things like that. So in any event, the court held that it was totally arbitrary to enforce this 3-person limit against unrelated individuals, but not related individuals, particularly if the house had enough bedrooms, plenty of parking, things like that. And of course, you can enforce, there's a nuisance if it's a party house type situation, you can enforce that directly through noise ordinances or trash ordinances and the like. That is a good cautionary case. So we won that case in federal court in 2019, York City of Bowling Green. Now, what happens many times is people like you hear about that victory, you share it with your careless bankrupt lawyer, or maybe the guy that handled your 4th DUI for you a couple of years ago, and they copy and paste my work into a complaint and a motion in an attempt to replicate the job just by that copy and paste, maybe use a little bit of chat GPT on the side, and that tends not to work. In these cases, they're the hardest cases to win. This is anytime you win a constitutional rights case, if it's not, something with a lesser degree of difficulty, like a First Amendment case, you're getting into sort of the triple Lutz and quadruple Lutz of law of any kind. And there are not many people that have won many of these cases. So if you have somebody without a track record of doing that, and you think you can just kind of hand this off to a non-expert, they typically don't do the right kind of discovery, ask the right kind of questions. And even if they won this case, Yoder in 2019, an individual in Kent, Ohio, did exactly what I'm describing, and his attorney tanked the victory that we won and got the opposite result in the Court of Appeals, in a suburban Court of Appeals outside of the Cleveland area, 11th District Court of Appeals. I noticed this loss and offered to take the case over and take it up to the Ohio Supreme Court. We had oral argument there a month ago, and we're hopeful for a victory. Now, this City of Kent ordinance was even worse than the Bowling Green ordinance. It was a restriction that no more than two unrelated individuals could live together. And our client, Mr. Havel, in that case, has a 6-bedroom home. So his 6-bedroom was limited to two individuals unless they're related. And the other thing that we know in terms of market trends that we all care about as real estate investors is that the household size is becoming smaller and smaller in this country. So this home was built in 1931. In 1931, the average American household was almost 5 people. Today, the average American household is 2 people. So, and that's, family sizes are smaller, less people are having kids, less families are living together, less extended family members living together for all kinds of reasons. This ordinance would have forbidden the Golden Girls from living together. The Golden Girls are a menace to cities like this, and they don't explain why. The reality is they're attempting to keep out student populations, but they can't say that because that would violate the Fair Housing Act because it's an age-based discrimination. So they twist themselves in contortions to come up with other reasons. Argument there was it's a violation of the general property rights and liberty provisions of the Ohio Constitution and impermissibly arbitrary based upon about 100 years of case law. Again, Ohio is more protective of property rights than the federal baseline. So this won't always apply in all the other states, although many states post-Kelo are more protective of property rights. Kelo v. New London is the case 20 years ago where the Pfizer Corporation took Suzette Kelo's home for a corporate headquarters in a viciously litigated 5-4 United States Supreme Court decision, causing a backlash amongst the states. And many of them said, our property rights are now stronger than the federal baseline. So that's that case. And I think it speaks for itself as to what it means for all of you. If you have a 4, 5, 6-bedroom home, it's a lose, lose, lose when these ordinances are allowed to stand. So you as the homeowner, you get less money coming in, you get less rent. The value of the home is commensurately driven lower by that. Your realtor is not happy because they're now selling the property for less if you're using a traditional realtor. And your tenants are less happy because they're having to pay more money for rent because now they have to split this giant home between 2 people instead of, say, 3, 4, 5, 6 people, split the rent and bring the costs down. And at a time when housing affordability is a real problem nationwide, more people living under the same roof is a huge way of solving that problem. And local governments are trying to obstruct that. And so we need to intervene as aggressively as we can when we see those kinds of regulations. And if anybody else has them, I think we want to be involved on the front end, even if we're not direct counsel in that case.
Yeah, the short-term rental of 2026, 15 years ago, short-term rentals were like the thing because nobody was doing them. Huge market, it was a blue ocean. It's not a blue ocean anymore. It's a red ocean. So the equivalent of that today is shared housing at pad splits. And where, yes, I have 6 bedrooms, I'm going to have 6 tenants with 6 different leases, and they're going to pay way less than they would pay for a 1-bedroom apartment, but way more than I would normally get for my 6-bedroom rental house. It
Yep.
it amazes me that cities can say out of one side of their mouth, "Oh my God, we need more. Rentals are so unaffordable. We have to have rent control because rentals are so unaffordable. We have to not let people charge security deposits because rentals are so unaffordable." But no, you can't have six people living in a six-bedroom house.
Yeah, and there are ways to create workarounds where the government raises a legitimate problem. So it is hard to get around, say, a parking restriction, but the reality is that if you're renting to millennials, not every one of them necessarily has a car. Or you can create off-street parking, or you can enter into a contract with the neighbor for additional parking. So, a lot of times when they run out of other excuses, they predicate this on parking. But the world is changing, and less young people are driving, less of that have their own cars. If they live in a walkable town, this is a non-issue. If they live in a downtown where you own this property, it's a non-issue. And you can create solutions to these other kinds of problems. So it really needs to be a wide open market. We need to do everything we can to fix that. Now, I will say a lot of the wins in this field are predicated upon the idea of the tenant group as a household or family unit, meaning they're all in a joint and severable lease, all four of them, five, six, whatever it may be. So what you're talking about is a little bit different than that. But the way that we've litigated this case is to protect shared housing in that circumstance. It's basically to say that the right is the right of the homeowner, the the housing provider, not the right just of the tenants alone.
Now, Maurice, before you go on to that fair housing case that you're fighting, I want to remind everybody that the way that you are able to not charge your clients anything is that you operate off of donations. And our real goal in life is to have you in court 100% of the time, not knocking around looking for donations half the time so that you can afford to be in court. So Deborah has just posted the donate button for ohioconstitution.org in the chat. And we've got 123 people here. If each person, donated the cash flow from one rental from 1 month for $200, that would put enough money into your coffers to like actually go fight another half of a case. And guys, these cases, he does have plaintiffs, so yay to them for being willing to stand up and do this because that can be very scary. But none of those plaintiffs should be paying to spend 2 years in court hearing suits that help all of us. I mean, it's all of us. So click that button right there while he's talking about this next thing and go in and put in your credit card and give him a couple of $100 so that he can just keep on doing this because this next one, the fair housing case, is likely to be earth-shattering if it passes. This is something that a lot of people have been very concerned about for a very long time, and I don't think anybody's actually taken the case on.
Fair housing. So this is a little bit, this is a brand new area for us. I'll say that. Now, we have to have some sort of a constitutional claim to get involved, and we actually have a few here. So the long and short of it is I've been hearing about this issue, again, both as a landlord and as a litigator for a while about these, I'm just going to use the term disability animals, which is a split the difference term that is actually different than every term that every court uses. But what we've noticed is the amount of housing discrimination, the supply of housing discrimination out there in America today does not meet the demand for housing discrimination amongst race baiters and other kinds of social justice warriors that want to try to manufacture more discrimination to enrich themselves because they're in the business of, creating discontent and hatred and division amongst people because that's how they make the money. And where that's sometimes the most prominent is in these fair housing organizations that pretend to care about fair housing for all, but are really trying to use the Fair Housing Act because they make hourly fees when they win the cases. And they do what is called drive-by litigation. And that means, and you'll see this in the disability context under the ADA as well, Americans with Disabilities Act, Fair Housing Act, where there's some sort of practice that they notice from a distance could be discriminatory. It could be the mere job posting that you post. And by the way, I see that I'm in a little bit slow motion on video. How's my audio?
The audio's fine.
Okay, great. So they literally pay somebody to surf Facebook Marketplace or wherever rental ads are posted or for sale ads are posted. And they see you say like no pets allowed or pet deposit required or something like that. And they say, that's our key. We're going to hire a guy to cold call all these people, pretend to be a tenant. Just some guy off the street, doesn't have to be disabled in any sense of the word. They're basically running a phone bank at this point, and get them to use magic language that is not quite right in the phone call, or in the email, more ideally for them, or maybe in a visit if they get that far. Well, they'll pretend to be an interested tenant and get into your house, ask you face to face. They are recording you during this time, and try to get you to say, in the case of our defendants, we prefer not to have dogs, but if you have a big dog, we charge a pet deposit and it's X number of dollars for the lease or for the month or whatever it might be. And we understand you have a disability and that's why you have the dog, but you have to pay that deposit one way or the other. So these people are called testers in federal law vernacular, and this practice began in the 70s when the Fair Housing Act was put on steroids, and they have way too much leeway. And the administrative state, as it's grown, has provided more and more protection for this practice. But the administrative state is being rolled back after Chevron was overturned a couple of years ago. What this means is the HUD, for example, can't make its own rules about how the Fair Housing Act should be interpreted. So the idea originally on substance, just on the substance of the issue, had been that HUD issued guidance during the Clinton administration that it was fair housing discrimination for you to charge the same pet deposit to somebody with a disability and has the dog or the cat or the rabbit or the kangaroo for the disability that you would charge to an average person off the street. In other words, treating the two people, disabled and undisabled, alike was unequal discrimination, nonsensical on its face. But we were forced to accept that HUD guidance in federal courts because we were required to defer to the agency. Well, that was called Chevron deference. That's gone. The Supreme Court blew that up 2 years ago in Wilbur Bright. So now we're free to revisit that guidance on the substance of the issue so that you could have generally applicable security deposits, for example, for these pets without violating the Fair Housing Act. Now, that's the substance. But what really gets to me is actually sort of the process behind this, where this theatrical performer, this actor, is hired to come out to your house and converse with you as though he may be interested in living there. And then the Fair Housing Agency that hired this fictitious individual sues you. And on the day they sue you in federal court, because they can charge you hourly if they win the case, and if your words aren't perfect, they think that they could win because they're very experienced in this area. On the day that they sue you, they usually will also send you a settlement agreement. Pay us $10,000, 12, 14, usually it's in that range, and we'll dismiss this case tomorrow. If they're really feeling their oats, they'll also add on the real insult to the injury, which is take our classes on how not to be a discriminatory jerk, and you will pay us $150 an hour to take these classes. So the settlement agreement is pay us 10 and then also pay us for 10 hours of fair housing training, like you need that at some outrageous hourly rate. And this is how they enrich their allegedly nonprofit organizations. Now, 1851, we're a 501c3, we're a nonprofit. Vina mentioned that. We're a charity. We operate on donations. And sometimes we can reverse the charge in attorney's fees case. These are fake nonprofits. They're a 501c3 just like we are, but almost all of their revenue comes from ripping you off in the way I just mentioned, or from government grants from the federal government, until the Trump administration, thankfully, has tried to yank those, which is hopefully going to diminish their size a little bit. But these are people that steal from you to function in the first place, but then their functioning is stealing from you more. And that's about all that's left. About 60% of the Fair Housing Act claims brought in federal court are disability animal cases at this point. And that's the whole universe of Fair Housing Act. Fair Housing Act protects against discrimination on the basis of race, religion, age, national origin. And across that entire universe, 60% of the cases are disability animals, because it's this slippery slope where they're looking to entrap you with the wrong words, the wrong scenarios. Imagine the scenarios you never saw coming. So, and some say that the enforcement actions are actually more than 60%, depending upon the study you use. So this is where all of the action is and remains right now in terms of housing discrimination. So you need to really be careful for yourself as a landlord. If I get that sort of a question when I was a landlord on Facebook Marketplace, I would just not answer it. I would just simply not respond to those people, not set up an appointment with them. And that's how I would attempt to handle it as a small scale landlord, as just sort of a practical advice. But the idea here is to prevent fair housing agencies from getting into federal court in the first place, because they don't have Article 3 standing, legal standing to sue, because they weren't discriminated against by you. Say you're the landlord and you said, yeah, I'd like to charge a pet deposit whether you're disabled or not. Or you just say, hey, show me your paperwork, prove that you're disabled to me, which is a vestige of discrimination in these people's opinion and in some courts' opinions. So you find yourself in this position. Who sues you? Not the fictitious actor, because they're not really disabled. You haven't discriminated against a disabled person. The Fair Housing Agency sues you with this sue and settle agreement. Our position is that these fair housing agencies don't have any more standing than we would have standing to bring claims to the 1851 Center as the plaintiff every time somebody's constitutional rights are violated. But it's our clients whose rights are violated. Essentially, these testers are just clients of the fair housing agencies, but they're fake clients because they're not even disabled in the first place. So the point is to keep them out of court and end this drive-by litigation, these sue and settle practices. And we have a client who's willing to let us try that. So we're in court now. That's in Dayton in federal court. And we're just sort of waiting for a ruling right now. We briefed the case. And I think this is going to be a longer case. We're going to have to either appeal or go through discovery in order to get to a victory. So I thought that might come quick, but we've got a very slow judge there. So it might actually be a while. But I do think that we will eventually, we are in a good circuit, the Sixth Circuit, for that issue. I think eventually we're going to get a good decision, at least on shutting down the fair housing agencies, which in and of itself will do most of the work. And if that doesn't do the work, secondly, we're looking for a decision that treating people equally with respect to these animals is not discrimination.
Okay, so if you were to win this, the outcome is what? They can't use testers anymore. They can't tell us that the pit bull I just adopted from the SPCA yesterday and spent $17 getting a letter online saying I needed it. You're laughing, but that's real, man. Like
all the time.
With a chain on his neck. Yeah.
All the time. Like what is the hoped for outcome of the win here?
By the way, for you Ohioans on the call, we've had 3 Ohio Supreme Court arguments in the last 3 months. And just before our first one, there was a very interesting case, not our case at all, about whether landlords can be liable for dogs that bite other people that belong exclusively to their tenants. So on the one hand, they're trying to force a dog down your throat. On the other hand, there is a bevy of people, and it's about a 50-50 split amongst the courts that say if this dog that you were forced to have within the housing that you own because your tenant claimed a disability, correctly or not, bites a third party, an innocent third party, or another tenant, you could be on the hooks for millions of dollars in damages on that, which your insurance may or may not cover, depending on the
Your
situation.
insurance might be canceled if you even accepted that breed.
Yeah, so this is a very serious issue. It's the inequities of it alone are bad enough, but if you add that to the mix, then it gets very ugly. Now, I want to make sure I got that in, but that wasn't responsive to your question, Vina, which was,
If you win this case against the I assume it's Miami Valley Fair Housing, is that who you're?
so I got your point. So testers will still have a place that we will never be able to fully end. And what I mean by that is, okay, let's go to racial. And the whole tester thing got started in racial discrimination. The idea is you have an apartment opening, you have a quiet policy of, say, only renting to lesbians, but you don't say that out loud because that's discriminatory. So the testing agency, the Fair Housing Agency, sends white males to you over and over, and you keep saying to the white males, this housing is unavailable, and then they send a fourth tester who is an out and proud lesbian, and you say, boom, this house is open, you've got it. So that kind of testing is something that we will not be able to shut down through this case. What we will absolutely be able to stop is so in other words, if it's a racial situation or some sort of physically obvious, we rent to anybody, but you tell 3 African Americans in a row the housing is not available. The fourth man walks in is white, and you say it's been available this whole time. If those 3 African Americans were testers, that's still a way that those agencies will be able to go after you and prove that you had discriminatory intent in who you chose to rent to. You should be aware of that. But when it comes to the disability phone banking, where it's just fictitious actors, theatrical performers, instead of singing musicals, they're pretending to be disabled over the phone and sometimes in person, because the range of what's disabled has grown so dramatically that a disabled person can no longer be physically identified based upon their appearance. That should be shut down almost entirely if we're successful in this case. And on the substance, generally applicable fees should be generally applicable to the entire population. And you shouldn't have special privileges for disabled tenants or buyers or other kinds of individuals. So it does away with, ideally, what are really special privileges or carve-outs where generally applicable policies don't apply to them.
Okay. All right. So you've also had some pretty exciting wins. You sent me an email several months ago that I just now got around to reading about Cleveland Heights. Does that not sound familiar to you?
That sounds very familiar to me. Here's what people need to know. The main thing that you need to know about the Cleveland Heights case is that Cleveland Heights wrote me 2 parking tickets in 2003. And as Christ says in the Bible, revenge is the highest virtue. I have been plotting revenge against Cleveland Heights for over 20 years. They had a policy that you could not park on the road overnight between the hours of 3 and 6 a.m. This, by the way, I was living with 4 other tenants in a 5-bedroom, and this was a backdoor occupancy limit issue. They said, hey, if you can't fit the cars in the driveway, we don't want that many people living in the house. And this is how they would enforce it. And I was a broke law student. My bike got stolen twice when I was pedaling to Case Western. The first time, I didn't know you needed a chain initially, right? But apparently you need to chain your bike up in Cleveland. Who would have thought? Everybody else knows this. I was the last person to find out. I learned the hard way. So Cleveland Heights wrote me 2 tickets, and I've been trying to get my money back for 21 years. So finally, we got a decision from the federal court last month that their what I'm going to call outsiders penalties are unconstitutional. What the outsiders penalty is, and this is increasingly common, there's a very interesting thing happening in our country right now. What that is even as we become more fluid and more mobile as a nation, as a culture, and less provincial, our policies are becoming more provincial at the municipal level. It's becoming more and more popular to blame the out-of-town landlord or the incorporated landlord for all the woes of the locals. The short-term rentals are what's driving up the property taxes, not the fact that we raised your property taxes. So whatever the issue is, we're starting to make scapegoats out of the capitalist players in the capitalist real estate system. This is an outsider's penalty that doubles the rental registration fees if you live outside of Cuyahoga County, which is the county that Cleveland Heights is located in. And the basis for this fee, if you want to call it that, was to get contact information from a local contact. Well, you already had the regular rental registration fees, which are just occupancy certificates up in Northeast Ohio, they're typically called. Where you already had to pay $200 and get this occupancy certificate to occupy your home to rent it out in the first place. So it's doubled that. So we're looking at $400 a year instead of $200 if you're a non-resident of Cuyahoga County. However, they already had the same information. By the way, this is always a ruse. At least in Ohio, your property tax, the auditor maintains your contact information of who pays property taxes on your properties. They always have a way of getting a hold of you without doing anything. But in any event, this was their argument. Well, there are two things going on here. So they have double rental registration fees on outsiders, which is unconstitutionally discriminatory because there's no basis for the discrimination. Especially true in a squiggly county like Cuyahoga. Our clients actually live closer to Cleveland Heights than some people that live in Cuyahoga County because it's a very horizontal county. And that, the judge found that interesting, but it's not dispensable to the ruling. What was part of the interesting dispensability to the ruling, and again, this is, if winning a constitutional rights case is the triple Lutz, every constitutional rights lawyer's dream is to win a rational basis case, which is the quadruple Lutz. And what I mean by that is to win a rational basis review case. All the way back in the New Deal era, the FDR court said that what are called economic liberties or property rights get secondhand treatment. They're sort of redheaded stepchildren. No offense to any of you here who fit that description. And we're going to only require a rational basis or a plausible explanation in order to win that. Very hard to win those cases. We didn't win that case for the stunning reason that the city of Cleveland Heights had repealed this ordinance in 2020, and yet the government lawyers for the city of Cleveland Heights continued to shake down the homeowners for this fee even after city council repealed it for years and years. And when I say shakedown, I mean they sent emails saying you're going to jail if you don't pay this fee, and you continue to lease your homes, make any sort of productive use of these properties while residing outside of the borders of Cleveland Heights. So it's hard to win a rational basis case, but one way to win is when the administrators at the city are enforcing a fee that the city council has in fact repealed. Now, city council repealed that fee by accident, and once we filed suit and we pointed this out, they reenacted it. So we also got to punch out that fee on its substance, not just on this sort of little wrinkle that gave us the rational basis winning. And this was a takings claim. The idea that charging this extra $200 to people who reside outside of the county is basically a mugging. It's indifferent than if the government administrator, the zoning inspector had walked up to you and pulled $200 out of your pocket and walked away with it. Because you got nothing for it, you got nothing in return. It was totally redundant to what you were already paying. So it's just a taking. And fortunately, we had a very good federal judge who wrote a very good opinion, finding that it was a taking of private property without compensation. Takings of money can be takings under federal takings law, and this was a federal case. So we're probably going before the Sixth Circuit, but it's a big win for us to stop this sort of discrimination against outsiders, particularly outside housing providers, on the one hand. Secondly, we return about $400,000 in these fees to the people who paid them all over the country, which we're excited about. And then third, we've created this great new precedent on rental registration fees being a taking. Now, let me be very clear on this. The kinds of rental registration fees that we are challenging, whether called rental licensing fees, rental registration, certificate of occupancy fees, what we're looking for to win these kinds of cases is specific, and I would say that it applies to maybe 50% of those types of fees out there. What we're looking for is what is the city doing with the revenue? So if you have a situation like this, here's what you need to do. You need to get on your email and you need to start documenting very carefully what is the city doing with that money? Because if they don't know what they're doing with that money, that is a tax or an exaction. That is not a user fee. Cities can impose user fees, and we're usually loath to be able to stop them from that. So the water bill fees, you use more water, you pay a higher fee. It's a user fee. We can't do much about that per se. But the situation where the city imposes a fee on you and then cannot give you an itemized breakdown dollar by dollar of what they're doing with that money, even better, they say, we just put it in the general fund. Well, the general fund is for general governmental expenditures. It's for police, fire, the general costs of government, not costs imposed by you. So what you're looking for is, are they tracking, are they carefully documenting the cost that you are imposing on them and charging you for that, or the benefits that you are receiving from them? And if they don't have any evidence of that whatsoever, and they can't tell you what they're doing with the money with great precision, or why the amount of the fee is what it is, you're in a good position to win that case. But you as the individual, as the client, as the entrepreneur, needs to document in writing only, never over a phone call, not in a meeting, through a public records request. If they won't provide it via email, you need to ask for a spreadsheet or an itemization of how they're using that revenue. And the best answer you can get back is, yeah, we don't know. We just throw it in the general fund. And you're going to win cases like that, whether it's an unconstitutional tax at the state level or an unconstitutional taking and exaction at the federal level. So that's what we're looking for.
Awesome. Okay, so we've got a couple of comments in the chat about some of these things. Like Evan thinks that he actually spends a great deal of time showing properties to testers that, of course, are never going to rent from him. Lots of comments. Does anybody have any specific questions for Maurice? Matt V does.
Can I comment on that comment?
Yes.
I know Evan has more properties than I ever had at my peak, but I believe if you are a hands-on landlord, it sounds like maybe he is. And for those of you who are hands-on and you're worried about these testers, one way I would propose to solve that is also a useful business practice anyway, is if I'm leasing out a unit, I'm having one open house. And I'm having the open house from 6 to 7 p.m. on Sunday in the summer, making sure it looks good, doing everything all, making sure that the place is all prettied up. So that's why I say it's a good business practice anyway, because you're making the place pretty once. You have everybody there, so you create the perception of demand because you've got 20 people there at the same time. You can't possibly service all of them. If one of those people happens to be a tester or two of them, what you said at some point to these people as part of the open house is the first person to put down the security deposit is who I'm likely to go with. And that never is going to be the tester because they have no intention of giving you money to rent the house. So if you fear there are testers, you especially want to be clear that I'm giving priority to the person that gives me a cash security deposit today or a check, and then you get to see also who signed the check, who wrote the check. But that's how I handle that as a landlord. So I would never have to worry about the argument that I didn't rent to the tester because of discrimination. It's because they didn't make the payment. And that was my tiebreaker analysis, irrespective of race, disability, etc. So to the extent that some of you are able to handle things hands-on like that, that's how I handle things as a housing provider.
Okay. So we got questions from Matt V, Linda, and Mike. In that order. Matt V.
I have
Okay,
my
let's go
mute
to
on.
Linda.
Can you hear me now?
Yes.
Okay. This is a kind of a tester offspring. I became aware that there is a digital compliance section in the ADA law, which until a few years ago was impossible to enforce, but now with artificial intelligence, you can run a website as to whether it's compliant with ADA. And there are millions of real estate investor websites out there that are probably not in compliance and would be easy shots for testers to go in and say, hey, this is not in compliance, give me 10,000 and it'll go away, yada, yada, yada. Has he experienced anything like that?
No, I haven't. It's not my precise field. I would be interested if this happens to somebody on here. I think I'm interested in getting more into these cases. Let me mention as an aside, one of the reasons I think we'd be willing to wade into this is it is an important sort of property rights issue that is not necessarily a command and control regulatory issue. But this is like a tax on all of our housing providers and other kinds of businesses as well. And one thing that I've learned just through wading into this Fair Housing Act issue is it's a loser pays system, which is a gamble. But what that means is the same reason that a predator like Miami Valley Fair Housing Organization wants these cases is because you have to pay their hourly if they win. Our hourly is $4.80, and that means that if we win, they have to pay us. So if we feel confident in these claims, I think maybe we want to jump in and sort of try to bleed these predators dry, especially there are some people that are just individual creeps at home who will file 10 of these cases in every state every year, and just try to make money on that. Like one individual with one, like creepy lawyer, and they just need shut down. And the way to do that is actually going to be for a nonprofit like us to jump into that ring and say, we're not billing our client hourly, because the lawyer who's billing you hourly is going to say, hey, just settle, because it's going to take me $5,000-$10,000 just to handle this case and even win for you. So just pay them off. And it's been a market failure. So I'm not familiar with the concept. I am generally becoming more open and interested than ever before than sort of wading into this, if any of you experience that, and attempting to win those cases for you and bleed them dry until they stop.
Where would you find it in the titles in Pacer, or how would you find someone who is practicing that?
Practicing the hit and run?
Practicing the testing. You're not in digital compliance.
Yeah. So yeah, you could do that. So first of all, I look at Westlaw for reported cases. Now, if they're doing this shakedown hit and run, they don't get to a decision in many cases. So Westlaw
Ah,
might not be a good source. So I go to Westlaw first to see the cases that were actually litigated by this individual or organization. But then, yes, if they are federal cases, PACER would give you you can put in the name of the individual or the lawyer and see every case they've litigated. Then you got to sift through, is that a case like mine or not? And then, yeah, I think that we want to do is build sort of a bank of who's doing this. And for me to go into court and say in my background section, this is the 20th case like this that this person has filed this year. And oftentimes, by the way, websites a little different, but the idea is that they have to say they have an intention to live there or an intention to visit there. Okay, you're going to visit or live in all these places just in this year alone. Obviously, you're lying, you know? So let's sort of play it that way. So I am interested.
okay, but there are, when you go look for a house or an apartment as a renter, you're probably looking at 20 or 30 websites to find what you need.
Well, that's
Just,
a
in,
point, but
just in a normal course.
that's an interesting point, but I would like to get into whether that person is a tester who's legitimately interested in living in that place, or instead whether that person is, say, a homeowner who is happily married with 5 kids and has no intention of moving, who lives in Beaver Creek, Ohio, and is looking for rental properties in East Cleveland for some odd reason.
Yeah. Okay. All right. Well, it just came up, and I know that there are millions of real estate investor websites. I haven't seen how big the digital compliance portion is, but if I'm guessing, I doubt anybody looks at their websites in terms of compliance with ADA.
There was a June 28th decision from the Northern District of Ohio. The reason I'm aware of it is the same judge who ruled in our favor around the same date, indicating that here again, just like you have these fair housing organizations, you have these like blind organizations, and I forget the exact name of it, but it was like, something for the blind. And
Right.
they found that they did not have standing. So the same theory that we're using here to we're trying to keep these organizations that are making bank as fake nonprofits from taking these cases. Because again, many times it's not the person who's going to sue you. It's a fake blind advocacy organization run by a bunch of, a bunch of baiters who are blind, don't care about the blind, just figure out they can make a bunch of money doing this. So the key on a lot of these is going to be who's actually running the complaint against you. Is it a fake NGO with your own money who wasn't actually injured by your website? And our view is they don't have legal standing to be in court.
Or someone that's actually qualifies for ADA as an individual. And then the question becomes, if they get an award in court, is it income or damages? If it's income, they're probably not going to want to do it because they are on so many government programs, their income would go up and then they get disqualified off of it. Do you know if it's income or damages, or is it?
I know it's the quote unquote civil rights lawyers running the show. So they're making hourly fees, so they're happy to do this, whether they're part of a fair housing organization or outside of it representing it. So again, that's where you've got to make them feel the pain. There's in people who call themselves civil rights lawyers.
All right, we have a bunch more questions, so
Thank you. I'm sorry I took up extra.
We're gonna need to move on. Linda and then Mike.
And Gene, also, I want to add to that last one. I have answers for his.
Okay, who was talking? I don't even know who was talking.
That was Jonathan. We can come back to it, but I have answers to those issues. I've gone through them.
Okay. Linda? Where'd you go, Linda? Okay, we'll go to Mike and come back to Linda. Mike Rukavina.
I think he's looking for his unmute.
I'm ready when you are. Sorry.
Go ahead, Linda.
My power's gone out like 19 times today, so it's messing up all my devices. Man, I'm rather pissed. Anyway, Maurice, thank you. It is a pleasure to have you on one of our calls once again. So I think I have a solution, at least I did when I did rentals, which I don't do anymore. But I created a Google form, but it was questions basically. So, how many people, when do you need it? What's your budget range? Do you have any pets? All these questions that we're supposed to ask each person the same way every single time. So this way, and I even told people if they called me, I need you to answer this questionnaire first, because to comply with fair housing, I need to ask each person the same question in the same way every single time. And never got any of those survey people because they won't do it. They won't fill out my Google form. So A, does that pass the smell test? Because I'm thinking of like a blind or low vision type person. And B, if it does pass the smell test, I will help anybody on this call set it up for free because I'm passionate about this issue.
Yeah, I mean, it passes the smell test.
Okay.
For what it's worth, I mean, personally, I think that a lot of the problems come from having application forms in the first place. So I'm anti-application form. I never use them. I would never consider using them. That's my own personal experience. Because if they do disclose, say, a disability or something else in an application form, and then you don't rent to them, then there's this additional factor. If you don't have the application form, say that they're multiracial, and they're just shaking you down, you can say, I never would have suspected this person was of a multi.
Oh, absolutely. The questions are all about their pre-questions. They're the kind of questions I would ask on the phone before,
Generally speaking, again, this only works for people of a smaller size, but I like the open house, anybody can come thing better than the application screening process, because I just find that most of the litigation that I see, when I know there's a denominator problem with me saying this, because I don't know the whole global sphere of experiences. I only know that what ends up in court, usually the application is the fulcrum for what ends up in court.
Okay.
Interesting. If you're not asking questions that would tend to go toward somebody's membership in a protected class, I can't imagine how. I have a written application from everybody. I run them all through the same point system. Here's why you failed isn't the best way to deal with that in court.
Yeah, and I don't like I say, I don't know the global sphere. I don't know all of the successes. I only see the failures. I see the breakdown of things that end up in court, right?
Sure.
So it might be that they work 99% of the time. It's just that the 1% that they don't comprise almost all of the court cases.
Okay, you've got some people in Dayton who would love to attend the hearing when the DMHA case is heard.
All right.
So you can let Deborah know when that's happening, and she can let Greater Dayton OREIA know.
If they have any intel for me, they're local. If they know anything about these kinds of shakedowns there, particularly by this organization, please send me tips. The more info I have, the better.
Okay, Michael.
Hey, evening, Vina and Maurice. I'm getting feedback.
You've got two things You've got two things on. Are you on the computer or on the phone?
No, I'm not on the phone.
That is weird.
Okay,
maybe we can.
Got signed in twice.
Maybe we can hear you well enough to get through the question.
Okay.
He's God.
Questions on the inspections. And I'm from the great city of Canton, one of the worst code enforcement towns in Ohio. On the city of Canton, what they started doing is if they see enough violations on the outside, they say that justifies an inspection on the inside. How does Maurice stand on that?
Yeah. Generally speaking, we really lucked out. If you're up there, Mike, that we're representing the Whirlwinds, who basically worked with us to make sure they had the cleanest property possible. So the city couldn't say that. That's how we got to the Supreme Court. So the city has to file a warrant application and put their evidence of why they deserve to have a search warrant in that application. And if they see housing violations from the outside, they may be successful at getting into the inside. It just is going to depend on what it is. So I've seen scenarios where they say things that are pretty flimsy. They'll say like, hey, there's peeling paint on the outside, or there's building materials stacked on the outside, and that suggests somebody who is a chronic housing code violator. So let us get to the inside. And I have, unfortunately, in the Cleveland area, seen some of those warrant applications be granted, not cases that we've worked on, but I'm just reading the cases in preparation for ours. And that, to me, is way too lax, and that is shocking. I do think that there are worst case scenarios on things that can be seen from the street or the sidewalk. If you have a glaring code violation, you are at risk, whether it's pursuant to an annual search or just a surprise search or a tenant call, obviously, if it's a rental. But a classic example would be a broken window. You've got a real problem on your hands if you've got a significantly broken window, because I, as the code inspector, can go to the court and say, I see a hole in this window. Bats could be flying in, birds could be flying in, rodents could get in. They can get into anywhere in the house. Therefore, I need to have the prerogative to search anywhere in the house. Now, if that broken window is in a detached garage, my view would be that is not a basis for getting into the house at all for any reason whatsoever. So it's going to be very fact dependent. But I think it needs a paint job, it has a hanging gutter or something like that, is not a basis to get. It's not enough evidence to search the entirety of the home. Take the gutter example. Okay, you've got this dangling gutter and it's leaking water up against the foundation of the house. At most, that would be probable cause to search the basement foundation for foundation issues, dampness, something like that. There would be no reason for that to justify the government searching the attic or the second floor or whatever. So, in other words, the problem they see has to lead them to the place they say they need to search. And all too often, what they do is attempt to search everything and not tailor it to the problem they say they saw. So if you find yourself in that situation, you need to push back as the homeowner. One of the problems that we're trying to correct through our litigation is that there's no reason for surprise searches. So the reason for a surprise criminal search warrant is, oh, this is a crack dealer, and they may flush the crack down the toilet if they know we're coming. So we have to go get a search warrant. We can't obviously notify them of the search warrant hearing ahead of time. But in these cases, there should be a hearing or a case ahead of time where you get to respond to the government about why they have no basis for being inside the home, or the basis that they claim is just dead wrong, or it only justifies a limited search. Again, detached garage, search the garage, but you can't search the home. So those are the bases upon which you need to engage with them. And obviously, if you find yourself in that situation, let us know and we'll try to be helpful.
Okay, and again, a couple of questions, but typically I don't have those problems because my property's in good shape, but we've been fighting city code for 40 years. I personally sued the city, etc. If I am doing repairs on the house that require a permit, such as some electrical upgrades or something like that, so the electrical inspector is entitled to come in for that purpose. Is he allowed to look for other things and then report to code to give them the justification for a warrant?
No, he's not entitled to search beyond the scope of the reason he's there. Now, if he sees something in plain view, there's nothing you can do about that. So he sees some sort of a crime. He sees marijuana plants growing in the basement while he's down there doing the inspection, and he reports that to the police. There's not much you can do about that because that's the plain view exception to the warrant requirement.
Okay, but I'm talking about other code issues, and I understand. I'm a retired cop also, so I understand the plain view stuff. But if he's there to inspect by electric, and he sees something about plumbing,
if he sees it and he knows, if he sees a leaking pipe in the basement, for example, when he's down there looking at the electric box, he can absolutely report that to the city, and they can use that as evidence to get a warrant to inspect the plumbing.
Okay, and final question. And like I said, we've gone up and down with a lot of issues with Canton over the years. And with Eric's particular case, they've kind of backed off a little bit on some things, but now they require every time the property changes hands, if I as a landlord sell to another landlord, they use that as rationale to require a new inspection. Is that legit?
No,
You already won that case, didn't you?
no. Yeah, we won that case against Bedford. We went against Oakwood, Pun v. City of Bedford, and Thompson v. City of Oakwood. So point of sale, pre-sale, and in fact, somebody won a case like that called Wilson v. Cincinnati back all the way back in 1976 or 79. So that's pretty well established in Ohio. Whether it's called a pre-sale, point of sale, the biggest issue is trying to pin the tail on the donkey in those cases. They'll often bring up the inspection at the last minute, and if the buyer agrees to it, then that's good enough. And so the buyer risks losing the deal. The seller is the one who's the actual homeowner, but they try to get the homeowner out of the equation, or they leverage the title department sometimes to not close the deal. So it just depends on how it's structured. But the seller is the person with the constitutional right to not submit to the search. So, but the seller oftentimes is on the way out, and the search will take place, when the buyer takes over, or whatever they find during the search will be on the buyer, so the seller doesn't care. So it was hard for us to get to those cases. It was hard for us to structure and win those cases. We literally had to use a father-daughter land contract in Bedford to get our first case on that, where they both cared, they both had an interest. So, winning that litigation is a game of pin the tail on the donkey, but no, it's unconstitutional.
Well, what should he do? Should he take that win to Canton and say you can't do this?
Yeah, absolutely. He should deny it, but he's got to be willing to risk losing his sale to do that.
Well, I'm more concerned again, because again, like I say, they've gone up and down on different things, but they just keep trying to find one way or another. If we beat them one way, they try to find another way to get in. And what they're doing is, like I say, if I become the new landlord by acquisition of a property, or if I sell it from myself to one other landlord, they're requiring an inspection for that new landlord. Whereas otherwise, theoretically, all we should have to pay is our theft fee, the registration fee that they hit us with every year, and they shouldn't have to do any inspections at all unless they're complaint driven. I mean, that's what you're saying with regards to the landlord situation and all that, right?
Yeah, I need to see the ordinance, but they can't. You have a right to sell property. It's probably the most fundamental right you have besides the bare possession. So they can't extort you when you attempt to exercise that right by taking away your right to refuse an inspection without a warrant. Now, if they have a basis to be in there, we can't. But if the only justification for the search warrant or for the search is you're selling it, that's not probable cause to search the property.
Okay, thanks, Maurice. Thanks for all that you do for us too.
Thanks.
Again, I know we've had some people who came in kind of late. I suspect that because they didn't translate 6 o'clock Eastern time into their own time zones. But I want to say again and have Deborah post again the donation link for Maurice. He operates with donations primarily. So Maurice, what does it take to get how much money does it take just in like time and court costs to get one of these cases as far as we have some sort of decision? I know it's more to take it to Supreme Court, but what does a case cost?
25 to 50, about 25 to 50,000. We tend to not start more than 4 cases a year anymore for that reason. So we're pretty stingy with what we do. The goal with any case that we select is sort of like a flight, and I'm the pilot, and I will fly a full plane on a short trip to a moderately better location. So if you're 200 people in Detroit, I will take you to Louisville. That is a case I will do. If you are one really awesome person with an awesome case that's very unique, but we are going to the Grand Cayman Islands, then I will fly just you and your family to the Grand Cayman Islands. So it has to be a very, very salient, unique kind of liberty issue or an egregious violation if it only affects a small number of people. But if you look at like the outsiders penalty in Cleveland Heights, that was something that affected 1,300 people, a very large group of people, and it was a nuisance. It was $200 a year, but some people have 30 properties. That adds up into real money for them over and over every year. But still, it's a ongoing nuisance, but it affects a lot of people. In either scenario, it's about a $25,000 to $50,000 budget for each case. Now, in some cases, we leverage those donations because we win the case and they have to pay our attorney's fees. Like in Cleveland Heights, we return the money, and ideally, I think our fee application is like 140, 150 right now. There will be an appeal, though. That's always the risk, is you might not ever see any of that. So, so if people who donate, one way of looking at it is that we take that money, we start a case. If we win our fees every once in a while, then we can kind of double that. But if you look at a case like CF Holmes or Havel v. Kent in the Ohio Supreme Court, where we're waiting for decisions that will really help everybody on this call, those are pure charity cases. We get donations for those cases. We're thankful for that, but there's no fee shifting opportunity in those kinds of cases.
Mm-hmm. Deborah, can you repost the donation link? And I'm going to figure out how much each of us has to donate to get one extra case through this year. There's 123 of us, so about $200 a piece would allow for another case this year. So guys, please click on that link and donate $200 or more. But if you're like, I can't do that, I'm a broke brand new investor, click it and donate $10. Put something into the pot so that we can keep this going and keep these wins coming. Jonathan and then Jake.
So a couple of things you were talking about earlier, the disability situation on websites. I don't know if it was like 3 years ago, but like they sued Keller Williams. They were just going after money that every site wasn't ADA compliant and all this stuff. So that thing has already happened and been resolved. So you might want to look at the case that was resolved to find out how that was resolved exactly, but it affected Keller Williams everywhere. There was also so you guys know, what's it called? Splash. What's the place where you get the free pictures? Upsplash, Unsplash, whatever. All those Pixels, Pixabay, and all those things. These are all places where you can use the photos, without issue. And I had an attorney running around and just threatening me to take down a picture. I said, I got it. It's licensed there. She's like, take it down. I'm like, I'm not taking it down. It's licensed. I mean, I had to fight her. She's sitting there insisting and being threatening and stuff like this. So they're going to do whatever they're going to do. There's so much of lawyers running around doing stuff. The third thing I was going to share with you all is look into a group called Termageddon. Termageddon. And this is a guy and his lawyer wife who allow you to put on your website. You answer a bunch of questions, like what state you're in and what type of business you run or whatever, and check a bunch of boxes, and it generates a policy, and you put it on your website, and essentially they keep you updated. Like if the law changes in Colorado, it's like changing every week. They update it and whatever, it's privacy and stuff like that. So it really deals a lot with terms and privacy, not so much ADA, but terms and privacy, and you won't have to keep track of it. It's like $100 a year and they're pretty much on top of it. So if you want to talk to people that are knowledgeable about that aspect of like web privacy, web terms of use, working with Europe and web site and stuff, these people probably are on the forefront of everything. So I hope that helps.
All right. Thank you, Jonathan. By the way, Maurice does take money from Florida as well. Jake and then Jeffrey.
Illicit, the way you put it.
I have two questions. One being, do you have experience fighting against city limits of banning short-term rentals, but continuing to allow long-term rentals? I've seen
a great question.
Yeah, no, I think I alluded earlier in our discussion to this increase in parochialness and provincialist, and I'm seeing people even in townships now attempting to ban short-term rentals or impose all kinds of regulations of all types. Burn Township in the Hocking Hills region, the most recent that we're looking at maybe litigating. They have a 2-acre minimum requirement and neighborhood veto. We like the neighborhood veto cases a lot, where they either cap, say only you can have 35 in the entire village or township or city, or you can have a short-term rental, but they have to be 1,000 feet away from each other, is another good case. There again, the registration fees, sometimes there are $1,000 annual registration fees, inspection mandates. So there are all kinds of, it's still a very fruitful area for litigation. The entire bans, I believe, unfortunately, and Airbnb themselves have really been negligent in how they've handled this in terms of what cases they've backed and what they brought, and also sitting on their hands too long, frankly. So the bottom line is the bans have become actually harder to fight than the regulations sometimes. But if it's a city that has, other kinds of like-kind uses that are permitted, or their zoning code has become idiosyncratic, then that's still open game. Especially if say you're in a township or a city that doesn't explicitly ban, but they just say only single-family residential, and short-term rental is not single-family residential. They're wrong about that, and that's a case that you can win too. So the long answer to your question is yes, I would be interested in the bans, but where the bans are the strongest is going to be maybe where there's only residential family homes throughout the entire community, whatever it is, or maybe there's some sort of zoning limit. But there's always an angle. It's just that it's going to be location specific.
Gotcha. In the city of Mentor of Ohio, they recently banned them last March. And prior to that, they had no verbiage of outlying short-term rental specifically. So I was operating. A lot of other landlords were short-term rental. And we even contacted the city, and they told us they frown upon them, but you're allowed to do them. And then they brought down I actually worked with council to create regulations and verbiage around taxes and things like that. And they still voted down 4-3 vote. And now they outlawed them altogether, sending out cease and desist letters, even though we were operating prior to that verbiage being updated in March. So that's what kind of the situation where a lot of landlords in Mentor are in with that short-term situation.
And I neglected to raise that there is this non-conforming use. You're sort of grandfathered in under the way that most codes work. Whether they say that or not, you have heightened constitutional protections if you were operating before and suddenly banned without notice. So usually you have a right to a non-conforming use, even if it's not written in that code. So that's another issue you might want to look at. In a city as large as Mentor, and Lake County is still a good place to litigate. 11th District is still a good place to litigate. And Mentor obviously is a large enough community that has every type of other use. So it is bizarre that they would outright ban short-term rentals. Well, I'm sure that there are hotels, bed and breakfasts, obviously long-term rentals, and all kinds of other things in the city of Mentor. So I think that could be a fruitful location for that.
Yeah, we have a lot of landlords that would be interested. It's just finding the right representation to do so and fighting a city, especially when there's currently that bill at the state level that may undo them potentially. Who knows? My secondary question might be related to your North Canton.
Wait, Jake, I need to time out for just 1 second.
Sure.
Scott and I need to leave this call because we have another one that starts at 7:30, as I think a lot of the folks here do. So I'm going to duck out, but we do have 2 or 3 more questions if Deborah can continue to moderate. And I just again want to say one of the biggest damn problems in our industry is that we all sit around and complain about this crap and we say, oh, these people should be sued. And then we don't donate $200 so that somebody can actually be the person who does that suit. So I'm going to ask you again, please click that link, ohioconstitution.org/donate, and put up some money. Don't sit here and be pissed off and say something should be done. This is like the way that most of us can do something about it, because most of us don't have $50,000 we want to spend litigating it all by ourselves. So please do that. Thank you, Maurice. Deborah,
Thanks.
take over.
Okay, so Jake, you said you had one more question. If that's pretty quick, we'll go on and have you do that. And then we'll move on to Jeffrey Williams and Kimberly Hale.
Thank you. A secondary question might be related to the North Canton case you mentioned, Maurice, and Mentor as well. They specifically have a rental ordinance when you register requiring inspections. They say in the verbiage that exterior is required and interior is upon the permission of the landlord. However, if you deny that permission, they deny you the permit as well. I know a scenario where they even granted a search warrant to enter the home. After fighting the search warrant in the court of law in a civil sense, the judge favored the landlord. They denied the search warrant and they showed up the very next day with another warrant under a slightly different reasoning and was granted access to the property. I was wondering if there's any direction in that scenario.
Yeah, not until we win in CF Homes, because actually the prevailing precedents, the prevailing one precedent that is in the way of the case that we're litigating in Ohio is a case called Kime v. City of Mentor, which is a really poorly litigated case by the landlords challenging the City of Mentor warrant requirement parameters. So that's actually the main case I would say that the government is relying upon. So Mentor has 4 aces in its hand, having won that case until we win our case. So that's a particularly problematic city for rental inspections right now. So until after CF Homes, and we'll have to look at that decision again and see what they've got. But the hope would be to abdicate Kime v. City of Mentor, which is just a lower court decision, that the Ohio Supreme Court overturns that implicitly in the case we're litigating now.
Gotcha. And the details of that case is on your website.
Yeah, that's right. And the Ohio Supreme Court argument is on our YouTube page, which you can get to through Facebook or YouTube. And it's on the Ohio Supreme Court's website. And they know what's going on. If you go to the Ohio Supreme Court's website, like every case before and after that has like 9 views, 21 views, and that case has like 40,000 views. So they know what's up and they know they take it seriously. So you guys checking it out there is actually sort of a nice pressure point. Hey, for everybody, one thing that you said, and I want to make sure everybody hears this, if the main way that we evaluate cases is through a notice and violation letter, where the local or state government writes you a letter or an email saying you are in violation of this policy in municipal code section X or revised code section Y. That way we have everything we need in that 1 or 2 page letter to know what they're trying to do to you, what their basis is. And I can look at that, sometimes look at the law, and within 5-10 minutes or an hour at the most, know whether we have a viable case or not. We get so many inquiries for cases where people do not have that. And it's just, hey, I got arrested last night or something, We can't really work with that second set of facts. We work with that first set of facts where there is some policy we're challenging and they put that policy in writing and say you are in violation of it or you will be. So that's exactly the kind of scenario we're looking for to effectively evaluate and litigate a case. And almost all of our cases start that way.
Okay. All right. Jeffrey Williams, if you want to unmute and ask, and then Kimberly Hale and Brian Krantz.
Thanks. Hi, Maurice. Jeff Williams here. We actually met at the State House Forum last year. That was a happy surprise having you come up there. And again today, I've learned a lot of very useful stuff, but I still don't really know how to put action on some of this stuff. You know what I mean? I mean, it's like, okay, so my question on the question board was, is a constitutional win really a win in today's world? Your organization gave me case law, City of Painesville versus Charles Cattell, that decided in favor of Cattell that municipalities cannot charge homeowners to repair city sidewalks or other issues in the right of way. And City of Hamilton, you guys have a case going against the City of Hamilton. I think you don't have a class action against the City of Hamilton?
No.
County? No?
Wait, City of Hamilton down by Cincinnati in Butler County?
Yes.
Is there a class action sidewalks in Hamilton?
Yes.
No, I didn't know anything about that case, but I'd be curious to learn about it.
Yeah, and I had I'd actually, somebody told me that your organization had a class action lawsuit against them on that issue.
No, I tell you what though, this is a great example. I don't know if anybody's doing that, but I would do more sidewalk cases. But this is a great example of what I was referring to a little bit earlier in the call, is you have to dot your I's and cross your T's when you're doing this. You can't just take our work and copy and paste it and expect to win. Because the sidewalk issue and what he's referring to, for those of you who don't know, is our position is that a local government cannot force you to repair government property, whether it's the sidewalk or the courthouse or the municipal building. They can't force you to go work on it, to clean the windows or to replace the windows, and they can't make you pay to replace the windows through a special assessment on just you and the people who live next to the courthouse, next to the sidewalks, next to they can't force you to fill a pothole because you live on the road where that pothole is. That is a general taxpayer expenditure. Now, that theory is specific usually to older communities where the government owns the sidewalk and you own the property up to the sidewalk. And that's going to depend upon whether it's in the municipal code or it's in maybe your deed as well. So our people in Painesville, their deeds were clear. They did not own the sidewalk or into the middle of the road. Sometimes they say, and the city code was clear that the city alone owned the sidewalk, which means anybody can walk out at any time. It's not your sidewalk. Now, that's going to be completely different usually if you're talking about like a subdivision type property, because those subdivisions are like dedicated and you have an easement. Maybe you own the road, but there's an easement. And there's all these unique factors when you get into like the easement analysis. So where we think we're solid and we'll do more work is where it's very clear that the government is claiming that it alone owns the sidewalk and there's no easement issue. Sorry to interrupt you, but I just want to make that clear, because if somebody tries to copycat case, but those facts aren't there, they're going to screw up that litigation. They're going to lose. And then they're going to be like, oh, well, did we really win ours? We really got to get under the hood before we start these cases. So I'm sorry to interrupt. Go ahead.
That's okay. So let's say it was true that, okay, the city of Hamilton owned the sidewalks and that's because this is an older neighborhood. My house is in this neighborhood are 120 years old. Nice big houses, nice old sidewalks with, trees pushing up the blocks, and the city.
This is the historical sidewalk case, right, Jeffrey?
Yes.
Okay.
Yeah. That was a historical sidewalk case, 1950 or 1851, I think. Yeah, 1851. But anyway, so the city of Hamilton, and again, as you had said, it wouldn't bother me a bit. I want to sell this house anyway, and I want to fix the sidewalk, but it's for them to do. Also, the trees that are in the right of way, they're requiring me to maintenance the trees. And I said, well, okay, I will maintenance the trees and I will maintenance the sidewalk. I will cut the trees down and get rid of them completely, because I don't want them. If they're mine, I should be able to do that. And if the sidewalks are mine, I want to be able to cut them or tear them up and not replace them. And so that they're basically wanting their cake and eat it too.
Yep.
They're saying, no, you can't do that. You can't tear my trees down without asking me. And I'm like, if it's your tree, it's causing damage to my property, I would like for you to get rid of that tree or to at least maintenance it. And they just, they won't. So so I have a precedent here that's municipalities in the state of Ohio cannot charge me to fix sidewalks, but they're doing it. So how do I fight that? What do I do?
Well, first of all, I would add more, unfortunately, I would add more facts that have to be true than the sentence that you just spoke. I wish it were true, but I would need to see the municipal code section where they're attempting to charge you. And by the way, the best case scenario for us is that they tell you can, and usually this is the case. They say you can pay us and we'll fix it. You can hire your own contractor and pay him and he'll fix it, or you can fix it yourself. We really only seem to have a legal bite at the apple where people have paid the government and in getting the money back or stopping that. Where you fix it yourself, if you've already fixed it yourself or paid a contractor, in other words, you made a payment to a private party, we do not have the tools in terms of the precedent and the claims to effectively recover those funds. So it's really where we excel is at cases where the facts I said are there, and then also the fact where the remedy in their eyes was that you pay them to make the repair or whatever it might be. And I will add to that, and this drives me nuts. The sidewalk thing and the tree lawn thing just drive me insane. I probably care a lot more about them than I should because of the damn hypocrisy of it. The idea that in so many cities, they tell you that you have to shovel the snow on the sidewalk, you have to take care of the sidewalk, you have to take care of even the tree lawn, which is the space between the sidewalk and the road. Yet then when it's convenient for them to tell you that you have no control over it, you don't own it, you can't use it, you can't plant anything there, you can't cut the tree down there, but you still have to mow it or whatever. It's just ridiculous. And they can't have it both ways. And there is some decent case law on this, and the door is open to improve it. So I am interested, and what I want to see is the municipal code section and what it says about who owns what. And if it doesn't say, then I need to look at the deeds of the property owners. And then here again, it's a small amount of money, and we're going to have the best leverage in court or outside of court is when you organize a class of property owners, basically like a union of neighboring property owners along this sidewalk or along this street, whatever it might be. Just one person howling in the wind is usually going to be considered crazy by the court. But if you can coordinate with your neighbors, and we have like say 20 property owners who all feel the same and want to fight this instead of just one rogue individual, we're going to have a much better chance of being taken seriously by the courts and the court of public opinion, which should not matter, but judges are people too, and psychological factors have a much larger impact on these cases than people would think.
Indeed.
Okay.
So, and I do have that letter, and I have actually, I did go to the hearing. And there were a lot of people there who saying, if this is public right of way, then, so I have other people who are wanting to do something also. But good. I need to, like you said, to organize them and then to get these letters off to your organization.
Yeah, I want to see what the city is sending to you. That's what I want to see is what the city is claiming and what they're demanding from you.
Yeah.
Okay. So we've got our last three questions, and then we're going to have to wrap it up for tonight. So Kimberly, if you'd like to go next.
Hi. My question's pretty short. I'm just wondering with this kind of topic, especially with rental inspections, interior rental inspections with cities, does it make a difference in pursuing these if the city has like home rule authority or not?
No.
Okay. Thank you.
Great. Thank you, Kimberly. I'm glad that was so fast. Brian Krantz, we've got you next. Brian, I need you to unmute. There you go.
Hi, Attorney Thompson. Brian Krantz here. Been a while since you and I chatted. I met you a couple years ago at one of the meetings. I put in the question marks about the city of Cleveland. They've got a couple of new things. One is their rental registration, and the second is their lead-free certificate. So my initial question is about the rent registration fee, which seems to become more commonplace. But the real piece on this one is they expire in March 1 of every year. So you can acquire a property, which we in fact did late in the year prior, pay the full fee. And in my case, I was thinking that we paid for an entire year, mistaken on my part. And it turns out that you pay for the entire year, but it expires in way less than a year. So we got the ticket in the mail, and I just heard you speak that it's helpful if we email you what the actual evidence is. That way you have something that you can work with, and that's good info.
Also on Cleveland, I think some of their, they have so many new regulations already in place up there and so many more proposed. One of the things I would like to know about the city of Cleveland's rental registration fees and other fees like that they're imagining and innovating is where the money goes, particularly in Cleveland, such a corrupt place.
I agree. I heard you say that before, and I agree with you that that point of view that you just stated is very pointed. Yeah. So there's that. And I will do a little bit of touching base to see if I can see where their money is actually going to. And we can revisit that once I'm, a little more prepared for that part of the conversation.
Yeah, please.
Then the next piece is this lead-free, which is perfectly fine, but there are two pieces that they don't address. One is that it does not exempt, I should say it does exempt actual homeowners rather than renters. So you could be a homeowner and have as much lead at your house as you want, but you have no reason to get rid of it. That's one. And then two, they don't speak to all of the lead pipes that are leading to the house and whether the city is getting rid of those 100-year-old lead pipes that are leaching lead into a house. It's kind of unfair that they hit us hard and say, oh, you, the homeowner, you, the landlord, have to deal with this, but they don't deal with it on their side. I don't know if you've already kind of looked at any of these things or not.
Yep, Flint got hit pretty hard in some class action litigation over that exact fact when all of the lead in their pipes was discovered. So that's a tool. You'd probably have to get some very precise metrics. I don't think it's a remedy to your problem because as you know, what they're doing on the lead abatement side in the houses is usually like lead paint type chip. Lead or paint chip analysis from what I understand. What seems to be effective in Toledo is making all of our people like licensed lead abatement people and then just doing them as independent contractors so that you're not getting some like government sycophant coming in and putting the screws to you. And there has been some equal protection litigation in Toledo about originally, they left out apartment buildings. I believe the year they pegged it to was pre-1973 construction.
True.
It's the same probably the same in Cleveland. There's some arbitrariness there, but that litigation, I wasn't part of that and it wasn't ultimately successful. And the city keeps rewriting the law to make it harsher. So if you say, okay, well, owner-occupied homes are not included, what they'll do is include some sort of provision to include owner-occupied homes, maybe not on the same fast track, but nevertheless. So that tends to be how cities are responding on the lead abatement front, because they're getting big federal grants and other things to get this done. So they're very, very motivated to cure whatever infirmity you point to. And a mere logical inconsistency alone is not going to be enough to win on that grounds. Now, if there are lead pipe issues, that would be a point of retaliation that you might want to look into, but that may be a lot of
gonna be a lot of work to discover for sure. Because some pipes probably have been changed. Many of them probably have not been changed.
Yeah, and I have no doubt their position in court would be, oh, we're going to get to that. We just haven't got there yet, and that's,
So what I heard you say, attorney, is that because the federal government is pushing this agenda, the cities are responding on it, saying, okay, we're going to go get this done. I heard you say that.
Well, you said pushing. During the Obama administration, massive federal grants were released to what I would call Rust Belt cities: Pittsburgh, Cleveland, to a lesser extent, Youngstown, Toledo, and then that amplified by the Flint situation, where more federal money was out there. So that's why you saw the ordinances come down the pike when they did. Cleveland, Toledo, within about a year of each other. Pittsburgh has one. Philadelphia has one. So you're sort of seeing it there and just there. So that's what's going on. So they are motivated, but they don't have, in most of these places, because they wanted this federal money, in their rush to get it, they didn't find people to do the lead abatement inspections. And so they ended up having to license just about anybody to go do them. Even like you could do like one a year. You can't do your own property, but you can do your friend's property, and your friend could do yours. So the folks in Toledo seem to have had some degree of success in getting decent people to just become lead abatement inspectors, and you might want to look into it. It's actually not a bad side gig. It pays pretty well. In flexibility as real estate investing. So just the thought.
I'm hearing what you're saying, although attorney, what you might not know is that, at least in the city of Cleveland, they've shut off all the lead abatement money that we would have been due for if we get the inspection done, and then there's money you can draw back on to cover the cost of that. But they've since done away with reimbursing people for that money. It may still be there. They're just not distributing it to the person who had to apply for it.
Yeah, so I need to see the mandate. I need to see the municipal code section at that point and what your options are.
Okay. So is that something you would prefer to research so that you get the correct stuff, or do you want me to just send you what I think is the right stuff, and then you can make your decision?
If you've received a letter from the city of Cleveland, send me that.
Yeah, that's always a good start. I agree.
Okay.
So I just didn't know if there was further background that we needed to email to show you what we're talking about.
Well, if it's a threat letter, notice of violation letter, or just a dear homeowner, there's a new mandate you should know about. They'll usually cite to a municipal code section that I can then go look at. Whether I know you have county council up there too, so it is.
I understand. I got you.
Rabbit hole begin. Yeah.
All right. Thank you, Brian.
So much. Thank you.
And Zachary, we've got the last question of the night.
Yes, Maurice, want to tell you thank you. We talked a while back with Painesville sidewalks and in a case there. So I know we're beating dead horse on sidewalks, but I didn't want to get into sidewalks, but many of the municipalities around here, most of the smaller villages, use the exact same village solicitor. And he's the same one for the city of Painesville. And while we fought those cases in Painesville and they dismissed every case with regards to the sidewalk abutments and everything, there's that same village solicitor is still pushing that same stuff on other villages, when he clearly knows that it's unconstitutional and he can't win these cases and he dismisses them. Is there a way to go after the solicitor though that's pushing this when he knows it's wrong? Like, is there like a ethics complaint through the bar association or something like that on, when you've got a prosecutor who's prosecuting cases that they're fully aware they can't win because they've already dismissed everyone they've ever taken to court?
Honestly, I just need better clients in that area. in all of those towns. That's what I need. I didn't know where that is. I need to look at each municipal code section and get in touch with people who have the right clients in the right place, who are the right clients in the right places, who are affected by these policies. And I think we're going to have to win. And ultimately, the way to put an end to this, in my experience, is that you have to win. Paynesville didn't really come to fruition because they backed off of it so quickly. But what would be an ideal outcome is a municipality that's charged a ton of money, and this is true across the board, not just in sidewalks. City charges a bunch of money. They get caught with their pants down. They made a mistake. They have to refund all of the money. It's very embarrassing for them, expensive for them. Their insurance probably doesn't cover it if it was a flagrant constitutional violation of the type that you're referencing. So you have to pay it out of pocket, out of their general fund, perhaps. And then that solicitor looks very bad for screwing that up and costing the city all that money. But also, it's a deterrent for other cities to say, hey, look what happened to Paynesville or Garfield Heights or Warrensville Heights. We don't want that to happen to us, so we're not going to pursue the same policies. So there typically has to be a financial component because that's all Ohio municipalities are, is just glorified cash registers for the people running them.
Right. Yeah, I was just curious if there's a way to go back to like I said, like on the ethics side, like as a lawyer or a prosecutor, you can't win this case. It's unconstitutional. You won't defend it. The times you've brought it forward, you won't defend it, and now you're bringing it again. I mean, I guess the way I look at it is like if I did something like that, I should know better, right? But it seems like the same guy just keeps doing the same thing over and over, and you're exactly right. We don't have good clients over here. They just pay the fees and move on, and it's that frustrates me from from the community side of it. Like we need to get our stuff together, but I just didn't know if there's a way to if there's another alternative besides fighting a case through the full legal process. Can you file a complaint, and is there any chance of it doing anything?
No, I mean, honestly, in the eyes of the Bar Association, there's nothing unethical about being incompetent, socialist, communist, or Marxist. Even though I would sentence all those lawyers to death if I were running the ethics department, because I would attempt to impose American ethics on them. But for that reason, I am not the ethicist in residence at the Ohio Supreme Court and never will be. So really the solution I need from you guys is for you to get your REIAs really well organized with people who have skin in the game and are willing to serve as plaintiffs in cases like that, because there is sort of a soft spot as the REIAs groups have sort of changed and developed in different ways up there, to where there are some parts of the state where I can call a REIA and they'll immediately sync me up with a person who has the problem that I want to solve. And there are other places where that's just not the case. And the better organized you guys are with the more different kinds of people and property owners, the better chance we'll have at fighting back.
Maurice, thank you, and thank you for all your time tonight.
Thank you.
Okay, so we're going to wrap that up. Maurice, again, thank you very much for all your hard work and all your time. I have put the link in the chat one more time, guys. So we're trying to raise, I guess, about $25,000 for Maurice tonight, if we can. So if you haven't yet, the challenge is to try and donate to him 1 month's worth of cash flow from one of your rentals. And hopefully we can fund one extra case this year. So that is our goal. So please take a look at his page and donate tonight. We'd appreciate it. Maurice, you have one more thing?
Yeah, hey, I saw there was like a couple of hundred comments or something, or chats. Will those disappear when we hang up, or is there a way for me to respond to those after the call is over? Will those be archived somewhere?
I believe they get downloaded. I can at least get them to you. We are recording this, so we will also send out the recording. There were quite a few of you that joined late, so that's great. We're happy to have you on here, but we'll try and get the recording so you can get the full information out. So
I just was in the middle of a sentence, so I wasn't able to really engage with the chat here. So, but I'd be happy to address those questions. And if they don't get addressed that way due to the folks can email us, info@ohioconstitution.org. or mthompson is my personal email address at ohioconstitution.org. I'm on a briefing deadline on that fair housing case through Friday, so you won't hear back from me this week, but feel free to inbox us with anything along these lines.
Sounds great. And I will do one shameless plug because I am in charge of it. If you want to hear Maurice again, he will be at our day at the Capitol on May 19th, hopefully with some of the, yeah, he's checking his calendar, but I already made sure it was on there. So hopefully he will have some of the decisions from some of these cases that he talked about tonight by then, if the Ohio Supreme Court gets those out to us. But he will be there. So will 100 or so legislators, as well as over 100 different investors from all over the state. This is a time and a great opportunity for you to come and engage and advocate, do this kind of work at a little bit different scale, and influence legislation before it becomes the legislation that we then need a court case to correct. So we would love to see all of you all there. It's May 19th. It's at the Capitol building in Columbus. There's a link. Thank you, Nicole. Again, you guys can click there, sign up at OREIA.com, and we love to have you there. Otherwise, we will see you guys next month, the third Sunday. That one is actually at our regularly scheduled time. So that's going to be from 7 to 8:30. Please mark your calendars from now on. The rest of the year, it's 7 to 8:30 on the third Sunday of the month. Thank you all very much. You guys have a great day. Good night.
Thanks, Deb.
Thanks, Maurice.